You guys are terribly brave souls to listen about IP while you eat, but we will try and make this fast, fun, and entertaining. When we talk about intellectual property, we typically talk about four things: patents, trademarks, copyrights, and trade secrets. Now, we're all among friends here. This is an intimate setting, so if you have any questions as we go through here, raise your hand. If you have any comments, feel free to chime in. This is a joint endeavor here. All right, first we'll talk about trademarks. Trademarks we're fairly familiar with. They are indicative of the source or origin of a good or service. And it's important to note that trademarks are designed to address the question of who and not what. And that means that if you are a small business or even a large business and you have a trademark, you need to be very careful in how you use that mark. You want to use it as an adjective and never as a noun or, God forbid, as a verb. And here are some dangerous slogans that even the most sophisticated of companies have used. And you've all heard these. Have you driven a Ford lately? Well, technically, there's no such thing as a Ford. There is a Ford brand vehicle or a Ford brand truck, but a Ford is not a noun. Have a Coke and a smile. Marketing department did not consult legal when they launched these things. And of course, you've all heard the phrase, would you go make me a Xerox of this? Xerox is cringing when you say that. Here's a few examples of well-known trademarks, and you'll see here that these come in pairs. The word mark here at the top is Starbucks, and it's got the little R in the circle, and that just means that it's been registered. And then we have the well-known siren below that you see on all your Starbucks coffee cups. And in this case, there's just a TM, which means that there are common law rights being claimed in that siren. Here's another example, Nike, and then the Nike swoosh. And these again are designed to indicate the source or origin of the product. Nike itself is not a noun, it is a brand. I always counsel my clients to file applications for trademarks in pairs. One is for the word mark, and then one is for any composite logo or design mark that they might have. And the nice thing about trademarks is that you can actually file an application for trademark registration at the federal level even before you've actually started using the mark. So if you've got a client who's ready to start a business, they already know what branding they want to use, we can go ahead and file an application for trademark registration as what we call an ITU, an intent to use application. And then later, when they actually do start using the mark, we can convert the mark over to a use-based application. Another example here, Holiday Inn Express, and then a very elaborate logo here that includes the sunburst theme at the top, the name Holiday Inn in a unique font, and then Express, and then you see the little R again right there. When you file an application for trademark registration, if you include anything that's descriptive like hotel and suites, you have to disclaim that because you can't be the exclusive owner of the actual name of what you're doing here. Trademarks are designed to protect consumers and not just businesses. They are actually a consumer protection statute. So if you want to see where some of the trademark rights might exist in the Tennessee Code, you can actually go to the Consumer Protection Act and find a long list of do's and don'ts. Some of those things will relate to how you represent the source or origin of your products or someone else's. So the issue here is not, are you stealing my name, but are you confusing my customers? So when I write a cease and desist letter to a company, typically I will not say, you're using my client's mark. I will say, you're acting in such a way that you're going to confuse my client's customers. Sometimes we have franchisees come to these meetings. A number of franchisees are members of the Knox Chamber. And so here's just a slide that tells a little bit about trademarks in the context of a franchise agreement. A franchise agreement is really just a fancy trademark license. The franchisor, examples would be Starbucks again, Five Guys Burgers, Qdoba, the list goes on and on, Pizza Hut, the franchisor owns the trademarks. And the franchise agreement will actually set out that the franchisor controls the trademarks, and thou shalt not ever, ever think about messing with our trademarks. You will not make any modifications to your signage or to your menus or to your color scheme or anything without our blessing and permission. Trademarks cover several things. It could be the name or the word of a company or product. It could be a logo. It could also include the color or decor of your store or your restaurant or even the shape of a product. And sometimes we refer to that as trade dress. Trade dress refers to the look, the shape, the overall feel, the ornamental theme, or color combination of a product. And here's an example. This is a company that has a chain of fast food Mexican restaurants called Taco Cabana. Anybody here ever been to a Taco Cabana? Typically have to go to Texas to find them. You can see here they've got this bright pink or magenta here with green, and I know the colors are kind of washed out, but that's a yellow and that's a purple, and this is their trade dress. And Taco Cabanas are ubiquitous in the Houston, Texas area, San Antonio, and even into Austin and up I-35. And the reason I mention this as an example is because Taco Cabana was involved in trade dress litigation several years ago. This is a picture of a fairly recent store. I don't know where it's located, but you can see that, again, they have the festive colors, the greens and the blues and the pinks. And, to be honest, if anybody here ever been to Miami, Florida? Every store looks like this with the palm trees and the, pink stucco, and, this could be South Beach or anywhere, but we won't worry about that today because they ended up in litigation. And here's a picture that was taken 20 years ago, and wait, look at that. What is that thing right there in the corner? Well, that's a plaintiff's exhibit sticker. And they sued a company called Pesos. And Pesos was another fast food Mexican restaurant with the same, decor and the same menu and the same theme, etc. And so a trade dispute arose. And it went all the way up to the U.S. Supreme Court, believe it or not. And the question is, can I claim trade dress protection for something that is, just the overall look and feel of a restaurant? And the U.S. Supreme Court said sure. And they described the trade dress of Taco Cabana as this: a festive eating atmosphere having interior dining and patio areas decorated with artifacts, bright colors, paintings, and murals. I'm still in Miami, but okay. The patio includes interior and exterior areas, with the interior patio capable of being sealed off from the outside patio by overhead garage doors. Well, that's pretty narrow, but okay. And so forth. It goes on to talk about the neon stripes and the bright awnings and the umbrellas. In law school, we have a phrase that says, bad facts make bad law. And that's really what happened here. The facts revealed that literally, in the dark of the night, Pesos went in, broke into the offices of Taco Cabana, stole their architectural plans, stole photographs of their buildings and so forth, and just blatantly knocked them off. And even the U.S. Supreme Court wasn't going to let them get away with that. So here's a couple of tips for a protectable trade dress. If you ever have a client that's opening a restaurant or a hotel, be creative. Come up with something very distinctive, because only distinctive elements are protectable. And then be consistent. The strength of your trade dress rights, just with any other trademark, exists in the fact that people recognize it and they associate it with you. And if you keep changing it, then you don't have a very strong trademark. All right, here's another example of some trademark litigation, and this involved a couple of tigers. Tony the Tiger versus the tiger in your tank, otherwise known as Kellogg Co. versus Xon Corp. Anybody in the room who's over the age of, say, 45 knows about Tony the Tiger on the box of cornflakes that you see advertised on Saturday morning, and putting a tiger in your tank, which is the old trademark for Exxon. And you know when you see the tiger that you pull into the gas station and a man in a bow tie is going to come out, pop the hood of your car, check the radiator fluid, check the washer fluid, check the oil, wash your windows, and pump the gas for you. Right? Isn't that what we all do now? Well, here's what happened. We've got Tony the Tiger, and he's great, but he's upset right now at this guy. And the reason is because this guy, he stopped hiring people with bow ties to come out and pump the gas for you. And instead, he started opening what? Convenience stores. And the convenience stores are selling cereal. And this is a problem. And so in the interest of full disclosure, our firm actually represented Xon in this case. And the defense that we had was we've been happily coexisting for a very long time, decades and decades. And in addition to the fact that there's probably not a likelihood of confusion here, people know you don't go to the gas station to shop for cereal, I think. And you're a little bit late in complaining about this right now. And the case went to the Sixth Circuit, and a series of factors here that are well known to trademark attorneys were enunciated and re-enunciated. And these are just factors that are used to determine if, in fact, there is trademark infringement, such as the strength of the mark, how related the goods or the services are, how similar the marks are, and so forth. Even the intent of the defendant when they selected the mark is a factor.